So let's talk about something that's about to cause a fundamental shift in our digital lives. These new digital personal data protection rules for 2025 are here, and trust me, they're about to completely change who holds the power over your personal information.
Think about it for a second. It's a simple question, right? But the answer has always been, well, murky. Every single time you click accept on one of those endless privacy policies, who are you really handing the keys to? Well, that balance of power, it's about to shift and shift dramatically. Okay, let's get into the weeds here. The Digital Personal Data Protection Act, or DPDP Act, was actually passed back in 2023, but it was kind of like having a brand new car with no engine. Now with these new rules, the engine is finally in place, and this law is ready to hit the road. So, what's the big idea behind all of this? Really, it all boils down to two main things. First, giving you, the citizen, real, actual control over your digital footprint. And second, making sure the companies that collect your data, what the law calls data fiduciaries, are held truly accountable for protecting it. The first huge change, and this is a big one, revolves around a simple but incredibly powerful idea: consent. From now on, your permission isn't just some box to be checked off. Nope, it is the absolute foundation of how your data can be used. Period. I mean, think about the last time you actually agreed to a terms and conditions page. It was probably a massive wall of confusing text, right? That's the old way. The new standard is all about clarity. Companies now have to tell you, in plain, simple language, exactly what data they want and precisely why they need it. No more hiding in the fine print. And this brings us to a really critical new term you're going to hear a lot: verifiable consent. This means companies can't just say they got your permission anymore. They have to be able to prove it. You can think of it like a mandatory digital handshake that has to happen before even a single byte of your data is collected. And this is where things get really powerful for us. The rules introduce something called consent managers. The best way to think of these is like a universal remote, but for your privacy. So instead of trying to juggle permissions across dozens of different apps and websites, you'll have one single registered platform where you can see, grant, and, importantly, withdraw your consent whenever you feel like it. All right, let's flip the coin and look at the other side. What are companies now required to do? Because it's not enough to just ask for permission nicely. They now have a legal duty to build what is essentially a digital fortress to protect the data they hold. So, what does this digital fortress actually look like? Well, we're talking about some serious technical safeguards. Things like data encryption to make your information completely unreadable to outsiders, virtual tokens to mask your real identity, and super strict access controls to limit who inside the company can even see your data. The goal is to turn every company's database into the equivalent of a digital bank vault. And for any high-risk activities, like handling massive amounts of very sensitive data, there's an extra layer of protection. Companies are now required to conduct something called a data protection impact assessment. Basically, it's a mandatory privacy audit to find and fix any potential problems before they ever have a chance to affect you. Okay, so you've given your consent and the company has its security fortress in place. But what happens if something goes wrong? Or what if you just change your mind? That's where your new rights and the official safety net come into play. Your rights are now crystal clear. You have the power to see exactly what data a company holds on you. You have the right to correct it if it's wrong, and crucially, you have the right to have it erased. You can even nominate someone to manage these rights on your behalf. This is a fundamental shift in who owns your data. The answer is simple: you do. Now, in the unfortunate event that a data breach does happen, the protocol is no longer optional. Companies must notify the Data Protection Board immediately. The rules literally say, without delay. And then they must inform you and everyone else who is affected with clear details on what happened and what the likely impact could be. And if you feel like your rights have been violated, there is now a very clear path for you to take action. You start by filing a complaint directly with the company. If they don't resolve it to your satisfaction, you can escalate it straight to the Data Protection Board, which will then formally investigate and make a ruling on the case. Now, beyond these core rules that pretty much apply to everyone, the framework also builds in some specific, much stronger protections for our most vulnerable users. So, this begs a really important question. How does this new framework protect the most vulnerable users in our digital world? what happens when it comes to the personal data of children?
Well, the answer here is completely unequivocal. For any company to process the personal data of a child, they absolutely must obtain mandatory and, that word again, verifiable consent from a parent or a guardian. This isn't a suggestion, it's a non-negotiable requirement.
And just to make sure this isn't some empty promise, the rules demand much stricter verification processes. This goes right back to that core idea of verifiable consent, ensuring that permission is genuine and that the protections for children are actually effective.
So that brings us to the big final question. We have a new deal for our data. We have clear rules for consent, for security, and for accountability. But does this mean our digital privacy is finally truly secure? Well, look, these rules are a massive, massive step forward. But their true power, that's going to depend on how they're enforced and how they're embraced by every single one of us.